So from the perspective of the defendant, I don't think they have proved anything in relation to affordability of bond, because she just doesn't know. Now, as to other matters, it is quite obvious that, I think from the evidence, as the court reads it, that this was a offense unique. According to Mr. Gross, we have a man who works here in San Antonio, although you're going to see in those records that he also listed at one point Laredo as a home address, that he had applied to a North Carolina company, that he was a trucker, things like that, did a lot of traveling. We do know that he has family in Mexico, even from Ms. Medrano, that, as she put it, they're related to his mother, so they're related to him, and that there is a home there, and that he has lived in Laredo. And the passport that was brought up in June, he applies for a passport for, what's the name of the, it's a .com, rushpassport.com. But when you take a look at the nature of this offense and how it is that this officer is just on patrol, and all of a sudden someone drives up next to him and takes out their rage for something on him by shooting him.
I'm sorry to interrupt you. I respectfully reject that. There's no evidence of those facts before the court. All that was before the court was very cursory determining facts, and we respectfully reject that as being outside the record.
Thank you, Your Honor. I think when you look at the affidavit and you read it, and then you read the number of times Sergeant Van was shot, which was 25, and the bullet fragments found at the scene, you have almost, when you add all that up, you have almost 40 rounds fired into that car. And that in and itself, from any individual, is an offense that is so egregious and so scary to the community and to the safety of the community. And one of the bond considerations for setting bond is the safety of the community. Now, this defendant also, you will see, was known to have a good many guns. He was found in possession of this. When you look at the evidence that we have linking to this defendant, I believe you'll see it really arises to proof evident, although we're not asking for remand without bond. It does rise to that level, I believe. And I would urge the court to, based on the record that you have before you, to leave the bond what was set by the previous magistrate. Thank you.
I briefly respond, Your Honor. It doesn't come anywhere close to remanding without bond. The state has to prove under Article 1, Section 11 of the Texas Constitution that not only that the proof is substantial in guilt innocence, but also that the special issues would be answered adverse to the defendant in the capital case. There's no evidence of that whatsoever. It doesn't even come close to him being remanded without bond. Had that been the case, the magistrate over Frio Street would have remanded him without bond. In this case, it was set at 1.5. We're respectfully submitting that there is no evidence rebutting Mr. Medrano on the fact that the defendant could not make a $1.5 million bond. No evidence at all rebutting that. Whether she knows about the actual specifics of the economics or not of the family, she knows they could not make a $1.5 million bond, and that was not rebutted. She said they could make a $50,000 bond, and that's it. We're respectfully requesting the court set it before the court.
I will deny bond reduction. I will require global positioning full house arrest as a